privacy regulation in a global context, considering new challenges like artificial intelligence, a quite lengthy title, and hopefully have some good idea what it means. We have some, but you're free to comment and what it will mean. With a quite distinguished panel here. We start with the lady here, Caroline Goemans Dorny. She's Interpol privacy officer, data protection officer, as they call it, EITPO, since January 2016. Before she was senior advisor at the Office of Legal Affairs of Interpol, and before that at Leuven University, research at the Interdisciplinary Center for Law and IT. And she was also in several EU projects, particularly Smart Respect, where also participated. So she can present the picture from law enforcement very well, and she will do that. Then next is Zoltán Précsényi. She is now Director of Government Affairs of Symantec, based in Brussels. And she's representing Symantec before EU and national legislative bodies. He worked before at the Public Affairs Manager for the European Aluminium Association, and before that as an advisor to a Hungarian member of the European Parliament. And he's a master, he's a lawyer also, like Caroline from the University of Paris 2, and so on and so on. Yes, okay. The next is Nico Hattingh. He is a solicitor attorney in Germany. He started his career at the Free University of Berlin. Then, since 2003, is in the in the lawyer's field. So he's now since 1996 partner at Härting Rechtsanwälte. He's also professor at the Hochschule für Recht, Wirtschaft und Recht, if I'm correct, in Berlin since 2012, and also active in the Deutschen Anwaltsverein and many others. And he's a strong interest also in what lawyers feel about artificial intelligence, the legal tech side. So, and last but not least, you know him very well, but he's still a student of Vienna University. But mostly now he's the well-known Max Schrems, a privacy activist. People we need who are making privacy a success in doing actually campaigning for privacy for civil society. Besides that, just from the details here, you see it on the website. Europe versus Facebook.org, a class action. Then here's a class action against with 25,000 participants against Facebook. Then successfully challenging safe harbor, etc. And you can also on Twitter. So we have some order. We start with the first question, and everybody will speak about 5-7 minutes, and then you have some words about the first topic, and then we start with the second one. The first question was a bit like artificial intelligence means for us here Internet of Things, but also data analytics. So tools are quite helpful, and we see it a bit more from the regulatory aspect. It's a competitive advantage for enterprises, and on the other side, how you can do privacy-friendly solutions. And then also an aspect you may say what you shall do, forbid it, only allow privacy-friendly solutions, or in the very end, accept how it is, as also Rainer Bosch mentioned, with several applications, apps on the market. The second would be then more, the second round would be more on this, what's really happening. So we know that compliance on a global level is low, too low. So we'll then work how we can improve that. And first, everybody will address what he's doing and what he considers as privacy friendly, and I can manage it. And we start with those who are very active in screening, as I called it a bit. The They screen everything, all the emails, maybe also websites, content for malware. And therefore, it's very interesting what they do. And the question is then, why not use the same technology for other purposes, hate speech, and so on and so on. So I give you the floor, please, Zoltán.
Thank you very much, and good morning, everyone. So I am here today representing, indeed, Symantec, who is the global leader in cybersecurity software and services. And we have a peculiar take on things like big data and, shall we call it, artificial intelligence or machine-made decisions. I think whatever name you attribute to this, it's something that's been with us for several years. And we in the cybersecurity industry have been using these technologies for a long time, among other things, to make our products more efficient, better performing, and more competitive than those of our peers in the ecosystem. To give you an idea, 6 years ago or 7 years ago, in our threat report released in 2011, we had said that we identified in the course of 2010 something in the range of 284 million unique malware variants in the year. Of course, for each of these, we will generate some sort of detection signature that our products can then integrate so that they then can protect our users against those identified variants. 284 million variants a year, you can calculate quite quickly how many a second that means, and you can understand that there is no way this can be done in any other way than by machines taking automated decisions. And this hasn't gotten any better since. In this year's report, which we released a month ago, we quote the same type of metric for the year 2016, and the number was 357 million unique malware variants. So obviously, we do have to rely a lot on artificial intelligence, machine learning, and automated decision making for deciding that a particular executable file is malicious and should be blocked. But this is only, if you will, one aspect of how we use big data and artificial intelligence or machine learning to make our products better. Because a couple of years ago, one of our chief technologists said that virus detection based on signatures is a technology from the past, because today it has become much easier to tell the good from the bad or the normal from the abnormal by determining the known good as opposed to trying to identify the known bad. What he meant is that based on sufficient information about a safe, healthy, non-dangerous executable, we can attribute a positive reputation to a file. For example, the install file of a popular application that doesn't carry any malware. We have seen it in 100 million instances, downloaded, used, not creating any cybersecurity threat. We can attribute to that executable a positive profile. We're doing that on the scale of our consumer and enterprise users on millions of endpoints with millions and at this stage billions of executables. And actually, detection of threats has gradually moved from detecting and blocking known threats to detecting and investigating unknown threats, because we know what is safe. We know based on sheer big data basis that this particular file will not behave badly. But when we come across something new, we don't know what it's gonna do. So that's suspicious. We will investigate it, run it in a sandbox, evaluate how it behaves, and then attribute, if you will, a reputation score. And we do that with executable files. We do that with web domains. We do that with a number of things, with applications, what have you. So we have been using big data a lot. We have been using machine learning a lot. We have been using artificial intelligence a lot to make cybersecurity more effective and to increase and preserve the protection of our customers. Which means that we have accumulated a great wealth of data, which we call generally under the generic term of threat intelligence. Within that threat intelligence, there is a lot of information which, under the definition of personal data as we have it in the GDPR, may qualify as potentially personally identifiable. And these would include things like IP addresses from where a particular threat has originated. That IP address could belong to the individual device of an unsuspecting user who has simply been compromised and whose machine is being used as a control and command center for a botnet, for example. So we have that kind of information, which in our hands is cyber threat intelligence, but in the hands of somebody else could be the identifier, for example, of the particular subscriber using that phone. And for that reason, it is very important that when we do that kind of big data application, big data use, even through automated means, in contexts where we as a company will never seek to identify who may be behind the machine or if there is anybody behind the machine at all, it's nevertheless very important to be mindful of the fact that, number one, the data in there might be privacy relevant. Therefore, all the rules applicable to having a legal basis for processing that data, needing to secure that data, needing to handle that data in confidence and using it only for the specified purpose, these rules must all be respected, and this is where it gets tricky. Because we are at the crossroads of two public policy objectives. One is the protection of the privacy of the individuals whose data we may hold in our various databases in great volumes. And on the other, we are hard pressed by all sorts of organizations, private and public, CERTs and CSERTs, but also in some cases law enforcement agencies, to share parts of that threat intelligence, not necessarily for the purpose of identifying, for example, a cyber criminal, but for spreading information and knowledge and awareness about cyber threats in general. How can we possibly reconcile the two? I think this is going to be the biggest challenge of the cybersecurity industry in the privacy sphere moving forward in the next couple of years, because on the one hand, I have no problem going through the guidance provided by the Article 29 Working Party back in 2014 on how you, for example, should use the legitimate interest legal basis of the 9546 directive and how you should establish your legitimate interest and balance it against the rights, freedoms and interests of data subjects. I can do that process. I have done that process as a company, and I can prove at any point in time that the processing I'm doing on the basis of legitimate interest for the purpose of security is acceptable. And actually, the fact that it has been recognized in Recital 49 of the GDPR tells me that this is well understood. But this doesn't mean that I can do anything else with that data. And in fact, I have to make sure that that data is not reused for any other purpose than what was strictly necessary and proportionate to the original objective. So what we're going to see is a conflict between our desire to accumulate more information, which we can do provided that sufficient safeguards are put around that, and the natural desire of the rest of the ecosystem to take advantage and to benefit from the wealth of information that we have gathered through information sharing, through other forms of disclosure like incident reporting, etc. But we will face a situation where we will need to make a judgment call. This part of the information, malware sample, for example, or indicators of compromise might be shared. That other kind of information, which may lead to the identification of individuals, may not be shared, or at least not voluntarily or not outside due process, etc. And this will require very granular and very detailed handling and management of cyber threat intelligence, so much so that we are actually in the process of completely revamping and redesigning the whole databases sitting under our threat intelligence-based services to make sure that we not only capture the threat intel itself, but also all the metadata around it to make sure that in case a piece of information is personally identifiable or maybe personally identifiable, we will have the chain of custody of that information to say where we collected it, who was the original customer, where it came from, because in many cases that will be the original data controller and will only be a data processor. At what time did we collect that information? For what purpose did we collect that information? So that at the end of the day, if asked, we can say, this is how we will, with respect to that data, implement the principles of minimization, the principles of storage limitation, the principle of purpose specificity, etc. It is tremendously challenging, and we have a big team of privacy professionals and IT engineers working on that. They've been doing that for 6 months, and I think we'll still be doing that in 6 years from now, but it's one of the most fascinating exercises I've seen, and I'm really thrilled by being associated to that in the company, and I'm looking forward to taking any questions later on. So thank you very much.
Thank you very much. Caroline, you have now a good food for thought for us and some statements, because when you see what Symantec is doing, shouldn't the police do this work worldwide and prevent all these threats? Also what sharing, meaning do you share data with Symantec, or you would like to share more data, or maybe it should be more helpful? But it's not, your role is a bit different one, you're a privacy officer, so you may say what you don't consider as appropriate. Thank you.
Okay. Thank you very much, Erich, and thank you for having invited me to this very inspiring conference. I'm glad that our cooperation continues after the SMART and the Respect research project. Now, the title of this project, or the title of this panel, was "Privacy Regulation in a Global Context, Considering New Challenges." So let me start with the privacy regulation in a global context, and to get back to the previous speaker. Of course, law enforcement is very envious of what they can do. I may disappoint you that law enforcement is very often lacking behind with respect to the possibilities and the resources that the private sector have today. We'll see how it will be in future. And regarding my position as a data protection officer, indeed, the data protection officer is an insider, but it's an independent insider. And I'm very happy I'm depending directly from the General Secretariat. I cannot be, the data protection officer cannot be instructed by directors, so it's pretty straightforward and pretty challenging as well. And now, as you know, Interpol is a Let us go back to this global regulation. Interpol is the world organization, as you know, for police cooperation. Interpol has an operational cooperation agreement with Europol, but Interpol is the world organization with 190 member countries. And so, in a nutshell, Interpol's mission is to serve as a global information hub worldwide for the law enforcement cooperation. And the way how Interpol accomplishes its mission has different means. One way is to provide a secure communication network between these 190 member countries. Another means is to make available global databases. Interpol has also products and services. Their product may be the most known product is the notices, the Interpol alerts. These are international alerts. They are color-coded. You have red, yellow, black, green notices, and according to the color, there is a very specific purpose. A red notice will be the most intrusive one because it's a specific request from a member country to provisionally arrest a person with a view of extradition. That said, of course, when you act worldwide, this is a huge advantage, but it also has a huge, goes together with huge challenges. Huge opportunities because you can, as a global organization, set standards globally. When there is a decision, it's globally made. Huge challenges, of course, as you know, because there are so many diversity between legislation, technicity, working methods. Police cooperation nationally is already difficult when you see sometimes in some countries the different entities between police and gendarmerie, for instance, well, let alone bilateral police cooperation is even more difficult. Regional police cooperation and then world police, global police cooperation, of course, goes together with huge challenges. So how can we make that global cooperation effectively working? And that since 1923, because Interpol exists since 1923. It's all about, we said it yesterday already, it's all about trust and protection. Protection of the individual and protection of the organization. And of course this is more and more true and challenging in that famous digital age. So the answer to make that cooperation happen is precisely to make sure that the cooperation is taking place in within common global standards, common global regulations. The more you get international, the more you get regulation, because the less there is trust. So you need a very, very strong framework. And in the field of privacy and data protection, the very start of the global framework is, of course, the Universal Declaration of Human Rights. So as a consequence, it's not just by accident that Interpol's constitution expressly refers to the European Declaration of Human Rights, including the right to privacy as the common standard for Interpol's action. And this reference to the Universal Declaration of Human Rights in Interpol's constitution has been articulated in a number of resolutions of the General Assembly and also, of course, first and foremost, in Interpol's data processing rules. Rome has not been built in one day. Interpol has a long tradition on data protection, and its first global rules on data protection were adopted in 1982. That is 1 year after the adoption of the Convention 108 of the Council of Europe, and it's about 10 years before the first general EU directive on data protection. And that very first regulation adopted in 1982 was in fact the creation of an independent supervisory authority for Interpol. And the background, just in a nutshell, was that at that time Interpol was moving its headquarters agreement from Paris to Lyon, was renegotiating headquarters agreement with the French government, and the French government wanted the CNIL, their data protection authority, to control Interpol's data. On which we said, yeah, Interpol is an international organization, there is something like independency and neutrality, and the information is not French information, it's information from all countries from all over the world. So that was in fact the decision and the agreement made with the French government to say, well, build then first an independent supervisory authority, the Commission for the Control of Interpol Files. As we know, privacy and data protection, again, we are witness with that today, are constantly in motion. Since then, since 1982, the Interpol's rules have been constantly been updated. I have counted since 1982 till 2016 10 updates with a very important reshape in 2011. Interpol rules on data processing has 136 provisions. I have some copies here if you would want, but you can find it on the internet, on the website as well. And yesterday, the EDPS representative very rightly stressed that security and privacy go together, and I would say nothing is more true. The more Interpol, we noted that the more Interpol expanded and enriched its privacy and data protection rules over the years, the more there had been an exponential growth of data sharing and requests for police cooperation via Interpol channels. And why is that? Because for effective police cooperation, which is Interpol's core business, you need to create really an ecosystem of trust and protection, both for the individual and the organization. This is precisely what global data protection framework can offer. And it's equally important, of course, that the framework is implemented not only in Lyon at the General Secretariat, but all over the world. And this is one of the reasons why each Interpol National Central Bureau, that's each contact point point in the 190 member countries, must designate a data protection officer. And I have this challenging task of developing this framework, developing this network of 190 data protection officers in the law enforcement sector at the Interpol National Central Bureaus, a network that I developed through all kind of means, with a data DPO corner on the website, by trainings, by visiting them, by organizing twinning programs, etc., etc. To give you some figures of today's police cooperation, which goes hand in hand with continuously updating a data protection framework, we count about 12 million queries a day on Interpol's databases. Between November 2016 and March 2017, Interpol handled 12,000 requests for police cooperation by means of these Interpol alerts, these Interpol notices. These requests for cooperation from member countries for very specific purposes, according to the color code, they must be before, when such a request is issued to the General Secretariat, the alert is assessed by a task force of about 30 persons within the General Secretariat to verify whether, in a nutshell, the request is in conformity with Interpol's constitution and with Interpol's regulations. So, in a way, the member countries can choose whether they cooperate or not with Interpol. If they cooperate with Interpol, if they wish Interpol's assistance, they are bound by the rules. There are also corrective measures, and their requests for cooperation are assessed by a task force. So in other words, Interpol makes its global network available for 190 member countries, but has a duty as provider of this network to filter out the requests for cooperations. Again, as I said, human rights observance and police efficiency really goes hand in hand. Because requests for cooperation needs to be accurate, relevant, updated to serve efficient policing. That's another example where really they serve both purposes at the same time. If you have an inefficient, an inaccurate request, it is a waste of time for the police as well, besides the high risks for the individual. So as a first conclusion, I would say global rules are not only appropriate, they are really the first necessity to make it happen, to make it work global-wise, and to serve both security and privacy issues. Literally, everybody is hooked up on the planet is hooked up with security and privacy issues. And I will finish by saying this conference is about privacy and data protection for the next generation in a digitally totally connected world. This is obviously also a hot topic within Interpol and national law enforcement. When we think of the huge challenges of cybercrime, we had already figures by the previous speaker. When we think that in 2016 over 1 billion records were stolen, hijacked, or hacked or usurpated on the internet. But the individuals expect that cybercrime is tackled in a way that respects individual rights. So law enforcement needs to tackle cybercrime with technologies at hand. The exponential growth of cybercrime also requires that the business models of the law enforcement should be revisited, be it from a technical, a legal, or an operational perspective. In other words, and there I come to the private sector, law enforcement can just cannot afford anymore to work in a silo. All sectors, private and public, are plugged in the digital world, and in this regard, the cooperation with the private sector needs to be developed. And we feel that whereas member countries were very, very reluctant to work with the private sector about 10 years ago, there is a tendency today to be more open. And in this respect, Interpol is carrying out pilot projects to work with the private sector, because of course we need to have guarantees. There are some risks at hand, and opening up more and more, there are also other issues than just privacy issues. To have a good collaboration, you need trust. You need the private sector has also its own interests. They have proprietary information. They are not always happy when law enforcement works with their competitors, all together in a cyber fusion center. So I would say. It's important to work with the private sector. Of course, in an ideal situation, the law enforcement would develop its own tools, but we are really not yet there. And there is a lot, but perhaps we can speak about it later, there is a lot to do with research on more transparency of algorithms. And I think one of the solutions is also, of course, privacy by default. I don't say privacy by design, it's really by default. It's not an option, it's really a necessity. In that respect, Interpol has done that since a long time, this approach, without using that particular notion. But of course, with big data analytics, you have also to revisit all that privacy by the default approach. Thank you.
Thank you. Thank you very much, Caroline. Now we see in the field of cyber crime, there's quite consensus that there should be cooperation. But now we move a bit more to the other side. There's a privacy, and it's not a crime actually. It's just a violation of privacy regulations. What we should do then in the global context, and maybe Nico Hattingh is an expert on that. He may refer to this topic. Thank you.
Thank you very much. Thank you for inviting me, and I'm very glad and pleased to be here. Let me say, smart technology needs smart regulation. And while the technology we are talking about is no doubt smart, there are a few question marks about regulation, if regulation is as smart as it should be. Let me talk about big data and artificial intelligence first. In order to understand big data, it is, in my opinion, essential to distinguish between the collection and storage of data on the one hand. That is the part clearly covered by the GDPR. The other part is the analysis of data. The analysis of data is only to a small part covered by the GDPR. When it comes to the analysis of data, there are issues of transparency, manipulation, discrimination, and as far as these issues are concerned, we don't really find answers in the GDPR. Protection against discrimination and manipulation. They are, in my opinion, a consumer law issue rather than a data protection law issue. They are there and they need an answer, but I doubt that the answer is in data protection. Data protection law works easily when we talk about the collection and storage of data. We have our principles in Article 5, we have the rules in Article 6, and so on and so on and so on. That works easily, but we don't really know what the standards are for analysis. As far as discrimination and manipulation are concerned, the issues that the GDPR really leaves open, we need to talk about ethics and we need to talk about control. When algorithms are used, there need to be ethical rules that prevent smart prices to be calculated on the basis of race or sexual orientation. When the household turns smart, there must be rules against discrimination on the basis of age or gender. There's also the necessity of control. Just as there are experts that understand how cars and airplanes work and whose duty it is to certify that vehicles are safe, there need to be experts who can and will certify that algorithms are safe. By the way, I don't believe in transparency of algorithms. I don't believe in transparency of technology. I don't understand the technology of the plane that is going to fly me back to Berlin this afternoon. So why should I understand the algorithm? What I need from the consumer perspective is trust. And that's where control and the experts come in. When we believe in the necessity of fighting climate change, we need smart homes. When we want our cities to be free of heavy traffic and congestions, we need smart cars and smart traffic. And if I may remark, if we want to be free of the worries of malware and spam, we need the technology that you were describing, the smart technology. When we want improvements and progress in fighting cancer, we need smart health services. In order to make smart technology work, we need privacy rules. The aim of such privacy regulation must, however, be smart regulation rather than merely protective regulation. I was listening to the lady who was explaining the e-privacy draft the Commission came out with, and she said, well, we don't put a legitimate interest clause in there because that would lower the level of protection. This is not a satisfactory answer, because the problem is we have legitimate interests as a basis in the GDPR, and while we have not in the privacy rules. This is inconsistent. And if I may just make one remark in this context, one further remark on the privacy regulation, we need consistency there. The GDPR, for better or worse, is not really heavily relying on consent. In many cases, we now, in the process of advising companies how to comply with the GDPR, we find we cannot really be sure that consent will hold, because where the main hurdle is that in connection with a contract, consent will only be valid when, or it will only be surely valid. There are questions of interpretation of the GDPR, but we will only be sure to be able to rely on consent when the consent only covers data that are necessary for the performance of the services. And if just to tell you an example, a car, yeah, you buy a car, or you sell a car, and there are processors, loads of processors in the cars these days that necessarily collect data. If you now seek the purchaser's consent for the collection of data of certain maintenance data, for example, you cannot be 100% sure whether that will hold, because this may be considered as data that are not necessary for the purchase, for the sale of the car, because you can sell a car without processing maintenance data. So the focus is very much on just sort of talking from the view of our day-to-day really advisory practice. The focus is very much on legitimate interest there. Yeah, that's the only option. You have to see whether this falls under the legitimate interest clause. And now comes the e-privacy regulation, where there are no restrictions on consent at all, where there are a lot of instances where consent is necessary. I'll make a remark about that in a minute. But there are no restrictions on consent, and there's no legitimate interest clause. And there are so many scenarios and cases, especially in the big data context. Everything that touches on what the GDPR calls online identifiers, where you have to apply both. And if this becomes the law, what the Commission has proposed, we have two sets of rules that are not that are clearly contradictory. So it is not a satisfactory answer to say, well, the privacy regulation offers more protection, so it's good. No, this is just protection, but it's not smart regulation. It's not regulation that will make technology work. And one particularly striking case where the regulation just goes way over the top is when in Article 6, you will know that, there's a clause that any technology screening communication needs the consent of both parties, which in plain words means when you have a spam filter or technology that detects malware like yours, you have to ask the spammer and the person sending the infected mail, which is just unbelievable. Yeah, so let's all keep an eye on the privacy discussion, and wherever I think there are various sort of takes you can have on the on privacy regulation, but there should be one. Now that the GDPR is through, there should be one consensus that whatever comes with the e-privacy should be in line with the GDPR. Let me make one, before I close, let me make one small remark on sort of law enforcement. There is, at the beginning, the lady from the Commission was saying, well, now the OTTs are going to be covered by the GDPR. And this is what is sort of sold by the argument that this meant level playing field between the big telco providers who are lobbying heavily for extending the telco regulation to the OTTs and the OTTs. It sounds good. It sounds great. But there is an Article 11. There's an Article 11 that leaves it to the member states then to introduce laws of interception. So the level playing field, if you look at Article 11, has a very has an aspect that needs to be discussed, and that cannot just pass with this very simplistic argument, level playing field. If the privacy regulation as it is extended to the OTTs, this means that the OTTs, whether they are big or small, whether they come from the Silicon Valley or whether they're a startup from Vienna or Berlin, that they will have to open back doors for law enforcement. There are good arguments for that. I wouldn't deny that, but this needs to be discussed openly rather than just discussing this level playing field argument.
Okay, thank you very much, Nico. Yeah, smart regulation, that's, sorry. That's a quite strong argument. Paper legislation is not smart, actually, because you need some human being read it and implement it. Max Schrems, you have some experience fighting against the smart regulator, because when you use some examples from at university, who is doing smart regulation as general terms of trade of this big five, they make the rules and then you have to comply with it and consent, and that's it. And therefore, in this global context, we can't ignore that privacy companies making rules, and then it's difficult what to do against it, also considering what states do against it, because they're not so effective as, interestingly, some privates. Please.
Thanks for the invitation, first of all. It's actually one of the points I wrote down. I have I just generally wanted to talk about privacy regulation in the global world as the topic actually is. And I do think, I'm kind of coming from the back now, I do think that's kind of what my case was mainly about, is who's regulating things. Is it the terms and conditions of a company, or is it in the end a democratic process that pumps out something like GDPR? And I'm obviously very much in favor of the second. I think the other thing we have to look into there is that we right now have a dominant player in a lot of these areas in the Silicon Valley, and in this combination we just see this American approach in a lot of regulation and approaches to it, as you said, the kind of notice and choice approach of we just put a lengthy old privacy policy there that says we do whatever we want to do with data, and you consent or you go, and that's just take it or leave it approach. And I think the GDPR actually does solve a lot of these issues, because it's clear now that it applies to everybody that is on the European market. We now do have like decent regulations of how consent should work, and this kind of notice and choice approach wouldn't work anymore in the European Union then, and all of that. And I think actually it would possibly enable us to regulate also on a global scale things that in a way that is privacy friendly, and that it's also enforced, because that's the bottom line problem that we had in Europe. We had all these wonderful and fancy laws, but if you don't enforce it, then there is no penalty, no one is going to care about it at all. And I think that is kind of the whole approach of GDPR that makes a lot of sense. This also leads me to another issue, and I think, for example, the safe harbor case is a very good example of that. Is the more we regulate all of these things, the more we have conflict of law situations. And basically, the safe harbor case was a simple conflict of law situation where Facebook is headquartered in Ireland and in the US under Irish law or European law. They cannot simply hand over the data to the NSA for mass surveillance. Under US law, they have to under 702, and this basic conflict of laws are getting really interesting. So far, we solved that basically by the government's not regulating it, or at least not enforcing its regulation. A lot of the conflict between the US and the European Union, I think, just didn't come up because the European side simply didn't enforce its laws, and this thing was solved by just sticking to the American laws. And I think the more we now moving into GDPR and other approaches of really regulating that, we will have to find also political solutions on these conflicts that are simply there. Because right now, for example, if you want to send data to an American cloud, I don't think that there is, in the long term, a legal basis that would sustain any challenge at the Court of Justice. And that is a problem, and we have to solve that somehow, because we can't have these tiny little clouds all over the place. But right now there is actually very little I think we can do about it. The second thing that you asked before a little bit more was the artificial intelligence and so on. And I actually join your view a lot that GDPR regulates a lot of the collection and all of that, but the whole analytics and how we deal with that was basically left out, because it was hard enough to agree on the easy parts. If we now talk about artificial intelligence and analytics and big data and whatever, that was the part where I think no one understood what it actually means by now. No one really knows what the rules should be, and everybody just said, we're going to do a little article on profiling and decision making and leave it at that, and I actually think a lot of the comments you made do make a lot of sense, because stuff like typical examples that we have, like price discrimination, is more of a consumer issue necessarily than a privacy issue, and probably we will need to regulate that there, and we did regulate that all over. We have rules, I don't know, in most countries, I guess in Austria, we have rules that you have to put a price at a supermarket on each article, and these rules are around, they're very ancient. Why don't use them online as well? I think a lot of that is probably better done outside of the privacy area. The other thing I think that's more interesting, and I'm really not an expert on artificial intelligence and analytics and big data and so on. I'm not that person. But I think what is going to be interesting is how much people accept kind of a black box decision. If it's artificial intelligence and we don't actually know how a decision was made over a person, we're basically building black box systems. And we did have that before. If you look back in history, why do we have procedural laws in courts? Because people wanted to understand why they go to jail or not. They didn't accept someone just saying you go to jail, whatever. And we introduced that, if you look into history, in many ways that we tried to get transparency, to try to get kind of a systematic system where you understand why a decision is made over you. And I think that is going to be very interesting, how we deal with that and how we implement that, because people will probably, that may be a part where people don't accept things anymore. They do accept a lot of the privacy violations because they simply don't understand what's going on. But if you factually don't get your contract anymore, or if you have a personal consequence in life, and the answer is going to be the computer that said so. There's Little Britain. I don't know if anyone follows a few, but there's like this old lady sitting on the computer saying, "Computer says no," and whenever they want to have a credit or something at the bank. And if the artificial intelligence does that in the end, I think it's people are going to like it as much as that person in Little Britain. But I think that is kind of oftentimes my take on these points. A last point that you ask is what is privacy friendly? I think in my view right now, it would be good enough if people just comply with the law. That would already give us a lot of more privacy-friendly life than we have it right now. And I think that could possibly solve a lot of the issues we have already.
Thank you. Thank you very much. It seemed to be a strong preference to have European regulation to make it work on the European market with all the different means. Also that those active in the European market should comply with European law, particular privacy law. That should be the first target. Then we should also consider that these new technologies like Internet of Things, data analytics, also these software agents, considered also a bit in the realm of electronic persons, like the European Parliament mentioned it. It's something a bit left a bit out. So, and also maybe the smart regulation is a bit not so much taken into account. Maybe also interesting for the public sector to use it a bit more than before. We see it a bit in the question concerning hate speech and also the attempt to ask providers to support a bit compliance issues on that. Just a few remarks on that. So we have now opened the floor to questions from the audience for the first round. Please. Yeah, maybe should we collect some questions and then you make a round again? Maybe that's the best. Okay, we start here with Kai.
Okay, Kai Rannenberg, Goethe University Frankfurt. I have two questions, especially to Niko, on your, especially on your statements about you're not sure that you trust and transparency of algorithms or something like that, but you rather would like to see trust. That's my first question. And I have a bit of experience in the area of trust building through assurance, through certification, security analysis, and so on. And in the about 25 years that I've been working in that area, it came out that trust into assurance mechanisms is basically achieved when the underlying provisions for coming to the coming to the analysis and the evaluation are open. So from that point of view, I agree that having an algorithm or anything like that simply available open source is not necessarily building trust in itself, because there need also be people to understand what that actually means. And we've seen with Heartbleed and stuff, we've seen stuff that was perfectly available for everybody, and it took ages until somebody understood that there was an issue. But to say I would not conclude from that that we do not need to have transparency of the algorithms, because if we don't have transparency of the algorithms, we have a much bigger problem to actually do any kind of assurance, because anybody who is doing evaluation based on not published materials, and we've seen that in long years of common criteria evaluations, is always under the suspicion, and unfortunately very often under suspicion that can be grounded and founded, that actually there was a subjectivity coming into the story. So from that point of view, I really would like to have a more refined position on the relation between trust on the one side and openness of algorithms on the other side. And then you came up on Article 6 of the e-privacy regulation, and you came on this and you came to this processing of mails or data outside, and that basically one receives, and you said, well, in a spam protection mechanism would then actually have to have the consent of the spammer. And I have a feeling there is a lack of smartness in industry, not a lack of smartness in regulation, because what we have as a situation, and that is an industry problem that we have. We used to have a spam provisioning from a major software provider, starting with M, ending with T. You can guess who you wanted, that we could build and install on our own mail servers. And then we could have the spam filtering. It was working reasonably nice. And eventually, that provider has moved his stuff into the cloud, And now this spam service is actually operating in the cloud, which means that we would have to move our mail into that cloud service, get it analyzed for spam and get it back, which we cannot do because the mail that we receive as a public institution, university in our case, is actually protected, of course, by a number of provisions that doesn't allow us to simply delegate the stuff out for analysis and back, which means that we needed to find a new solution for spam. And the solution that we would want to buy and even will pay money for, an analysis for spam on our provision, neatly integrated with the mail service that otherwise we have, has actually gone away. Now, if we look at Article 6, it basically says if the communication provider does the spam filtering, then there is a problem. If the spam filtering is happening on the premises of the receiver, this article actually is not holding because we're not a communication provider. So what I would say is I fully understand that Article 6 is here because, I mean, I don't want to have centralized filtering of things for spam which then can endanger the protection and confidentiality of communication, which after all is the idea why the e-privacy regulation exists, and I don't want to have that undermined by a spam filter, but what we actually need is a smarter industry that is providing me the tools and actually continuously and dependably providing me the tools that I need, which means basically I want a tool that I can assess, and then I can operate it on my own premises, and then I can do the spam filtering that I need to keep operational, and at the same time don't endanger the constitutional or other values that I as an organization need to defend and fulfill. So I have a feeling we have a lack, and I've seen a few other examples of that coming from providers which were very cloud-oriented or became very cloud-oriented. My feeling is in some of these, and yesterday we had a similar discussion, my feeling is some of the criticism of the e-privacy regulation is not coming from a lack of smartness of the regulation, but from a lack of analysis of the technical opportunities that exist in principle by which industry can fulfill requirements, and by giving users and users a choice and saying, I want this and not that.
Okay. Next question. Please. Okay.
Christian Jaksch, PhD student. I've got two questions. The first one is to Mr. Härting. It's about your speech to the e-privacy regulation, and I want to ask if the problem with the consent is this not a political problem, because in the presentation of today of the e-privacy draft, it was said that the reason why there is only the option of a consent is that the European Commission is seeing that communication data are sensitive data, and when they are sensitive data, you don't have the legal basis of the legitimate interests. That's the same with health data. And they see the electronic communication data as sensitive data, so no legitimate interest. So I think it's more a political question. Should we see electronic communication data as sensitive data or not? And I think out of the historical perspective, these are sensitive data, but maybe the views have changed. So I think that's the key point. And the second thing is to all. The question is, in Article 5 we have the order that data should only be processed in a fair way and in a transparent manner. And is this not enough for when you use artificial intelligence for a judge? Then he gets the analysis from a specialist, and then he can say, yeah, you processed the data in a fair way and in a transparent way, or you did it not. And then it's a violation of Article 5 GDPR, or it is not. So maybe the law is clear. That's my second question. Thank you very much.
Thank you. Next question.
Hello, I'm Lina Jesman-Tijten from Free University of Brussels. I would like to follow up on Nico's suggestion that smart regulation would make smart technology work. And in your particular view, you were suggesting that we need ethics, and ethics could provide for some solutions to that. It's indeed a very interesting proposal that comes back time and again in the discussions on the implementation of the GDPR and in general regulation of innovative technologies. But as a lawyer, I'm not entirely convinced with your suggestion. The ethical approach would not be sufficient to shape business practices, to respect individuals' rights to privacy and data protection. And we have to admit here that businesses are driven primarily by the economic interests and not the protection of individuals' rights. And therefore, I think that ethical rules wouldn't be enough and would come at a certain price, and that price would be the protection of individuals' rights. And perhaps some other panelists and you yourself could elaborate on this observation. Thank you.
Thank you. Next question. That's here. Yeah. Mr. Prowse, yeah.
Sorry.
So it's here. And then we move here. Okay.
Yeah, hello, Peter Kraus, DFS. I have two personal questions, and they're mainly focused on what Nico was saying. And one's like, he was saying that he doesn't believe in transparency, and Kai already hit a bit into that direction. But I come from a science background, so for us there was always the differentiation between knowledge and belief. And you can have only knowledge if you can understand something and have transparency. Otherwise you have to believe into something, and then we have maybe a religion about data protection, but not necessarily something that's useful for society, at least in my point of view. So I'm a bit confused and would like if you can clarify that point, because I'm pretty sure that most people agree that open standards are something that helps with transparency and helps with data protection. And the second point you made was that you said that you don't believe that the e-privacy regulation will make technology work. And I have to agree on some extent. Regulations don't make technologies work, engineers usually do. So the limitations that are in there will be limitations to what people can do, but from my experience, people are very resourceful and they find ways to go around it or deal with it and implement what they want to do in a way that is compliant. So it might just be an additional challenge that will result in new technologies, and I'm very hopeful that people will find solutions that will implement both, like the data protection aspects and the economical interests.
Thank you. Next question, it's in front. Who is? Yeah. Yeah, here and then he is in front, please. It's here. You would like, and you also? Okay. Then we close the round here. Yeah, please. Yeah.
So, yeah, thank you very much. And thank you to all the panelists for an extremely interesting discussion. I have a question for Nico Hattingh. As you certainly know, every time somebody tries to audit an algorithm, he immediately hits the stumbling block of liability. The provider will never sign off on any kind of certificate because he cannot control the data set that the client will eventually feed into the algorithm. And likewise, the client will never accept an algorithm per se because he cannot control it unless the level of disclosure is such that it infringes upon the intellectual property of the provider. How would you resolve that conflict, if at all possible?
Okay. So thank you. I'll now have Niko to answer many questions, and then the rest.
Let me try my very best. Well, most of the questions, or many of the questions, were about what I said about transparency. And I think I should be a bit clearer on what I meant when I said I don't believe in transparency. I don't believe that the consumer is able or will be able to understand the technology. That is what I meant. I think the belief that you can that by creating rules, you can make the consumer understand how the technology works. I find this notion frankly naive. This does, of course, not mean that that in contractual situations, like you just mentioned, or I said, my point was we need control, and of course, whoever is the control, whoever is the has the job of controlling algorithms, of course, that person needs transparency. Yeah, and this is and when we talk about open standards that were mentioned a couple of times, I'm a great friend of open standards, but they don't make. I don't understand the technology even when it's open standard. You will, because you're a scientist, because it's your job, you're a scientist, and I'm all for that. But I just my point is just that creating rules that lead to lengthy explanations of how algorithms work. This is what I don't believe in as a sort of appropriate way of regulating algorithms. Let me continue with your. I liked your comment that, well, the e-privacy regulation is not too bad because you will find ways around it. Yeah. Of course, it's my. I mean, this is my job as well, finding ways around it. You know, when the law is. This is what a creative lawyer will always do. Yeah, he will interact with the clients and with the IT people there, and will see how to just sort of make it work. But this does not mean that the law is good or bad. Yeah, so this is not a convincing argument in favor of the e-privacy proposal, in my opinion. And well, and another comment. A friend of mine always says, well, we should just for one day, we should implement data protection law 100%, and then everybody would see how stupid it is. Or in other words, the often observed, rightly observed, problem of under implementation might be just part of how we can survive with the data protection law as it is. And if I may add one further comment, this is not going to change with the GDPR. If you talk to the DPAs at the moment, at least in Germany, they have presently no clue how to implement the law in May 2018. Presently, they are busy just doing their day-to-day business. I have been at a few sort of just conferences like this, really, where people from the DPA met people from lawyers like me. And we are, in a way, far ahead because we are working with the GDPR every day now. The people who are working the DPAs are not. Yeah, they have to sort of find time to understand and learn the rules of the GDPR. So we will all see what's going to happen next May, but we will definitely not get close to implementation. There were
ethics.
Yes. Let me first of all make a comment to this, or pass on the question on spam filters to you, because I think you can answer that better than I can. To my understanding, the solution that you described, that the spam is filtered out on the server of the recipient, just doesn't mean that all the mails that were sent to this server actually land on that server, because most of the traffic is filtered out before such spam filters are used. Is that my correct impression?
That will depend on how the solution is architected. There are ways where at the network or at the provider level there is a spam filtering solution put in place, in which case that problem doesn't exist. But you're talking about the spam that actually reaches you for some reason, so hasn't been blocked in the meantime. On that point, I would say that there is I think there is a mismatch between how smart the technology is, or what the technology is being smart for, versus what the legislator is being smart for. What I mean is that in the case of something like spam filtering, not offering an on-site version of the product could be very smart from an economic performance, scalability, efficiency standpoint, but it's not smart to meet a requirement that you are under because the legislator in Austria considers that you should make sure that you only use solutions that are on-premise. Is it a question of the technology not being smart enough to meet this Austrian requirement, or is it the question of the Austrian requirement being not smart enough to meet the technology, to make the best out of technology? That's open for discussion, and I don't want to take any sides. This is the reason why Symantec, for example, offers data loss prevention technology both on-site and hosted. We have two options available. Having said that, while I have the mic, I'll hang on to it and make a couple of points, if I may. First, to the question on companies' priority not necessarily being individual rights protection. I wouldn't necessarily oppose the two, and in the case of my company, we very much like to think of ourselves as people whose technologies make things like the protection of privacy, the technical protection of data processing facilities, actually a real possibility. So I wouldn't necessarily oppose the two, and in our case, our business value proposition is precisely the protection of information, which goes very much in the same direction as the protection of privacy. So I would say that there are business models in which there is very good congruence between protecting individual rights and achieving business outcomes. Now, coming back to the smart legislation point and e-privacy and the consent problem, I will give a short example of why I agree that not everything in Article 6 is actually as smart as it looks. And let's take the example of an IoT setting where a machine communicates with a machine. It's an electronic communication based on recital 12 of e-privacy. The transmission of this communication should be in scope. This communication will involve metadata, source, destination, and other attributes of the communication that may contain indicators of compromise, in the sense of it could be that the source is a device which I know to be infected and malicious and distributing malicious content. The content itself that is being transmitted may contain malicious payload and therefore need to be processed to be filtered out, detected, blocked. Under e-privacy, only those who are in scope of the electronic communications code could process that metadata and that content data without consent, and only for the purpose of the security of their own services, which is completely missing the point that this threat could be to the security of the user, of the device, or of third parties. I, as the security vendor, have no legal grounds in e-privacy Article 6 to process either metadata or content data to filter out malicious content or block malicious traffic. I know it's not intentional, but the combination between the definition of scope under the code and the definition of permissions under Article 6 of e-privacy results in this nonsensical situation that those who are in charge of delivering security do not have a legal basis to do it, whereas they do in the GDPR. So there is some room for improvement. Now, there was a question about whether, and you both raised the question of whether the GDPR... Yeah.
Yes, if I just may, I don't want to leave the two questions open that was still there. I raised ethics. Law and ethics, this is not an either-or. We have ethics in, I'm a lawyer, and we have, as a lawyer, there are rules, regulations, but there's also ethics. Same with doctors. And my argument would be, same with software programmers. And this doesn't mean that ethics are, that where there's ethics, there doesn't need to be regulation. But there needs to be ethics, and there needs to be a discussion of what these ethical rules should be. This is definitely a discussion that where we lawyers should not sit in the front row.
It's more a question also who should do it, actually, if I understood it properly. It's a question who should do it, the machine, the private company, the police, the judge?
Society. That would be my answer.
But someone has to do it also then.
Society. I mean, I could mention now that there's a very interesting project called Algorithm Watch going on in Germany at the moment, together with Zeitstiftung. If you're interested in that subject, and there's Stefan Noller, who used to be the CEO of Nougat, who promoted algorithm ethics some years ago, and wrote some very good and interesting and thoughtful pieces a few years ago about that. But this is, as I said, this is well, to the non-lawyers, keep the lawyers out of that discussions. Lawyers are not good at discussing ethics because we don't really know how to deal with it. Then your question, is this a political argument when you say a consent is necessary everywhere? It's a strange argument because it doesn't really go, it's more a sort of legalistic argument. Yeah, it's an argument, well, there's health data in the communication lines, so this is sensitive data, full stop. But this is not really, there's no thought to the consequences of this, and there is no thought to the logic of the law, of the rules. This is very, very legalistic. And I can't say, I could say very much about it, but I try to, just a very, very short answer. E-privacy, if you compare the e-privacy directive with the e-privacy regulation, and if you look at what is defined as the aim, from the top of my head, the aim of the directive is to protect against surveillance of communication, and surveillance and interception, and in the regulation, it's suddenly from the dangers of or risks of electronic processing. So that's just a shift of focus. Whilst the regulation and for the sort of who, like us Germans, have a special protection of telecommunication, we are used to see the necessity to protect communication against interception. Now we suddenly have the consumers to be protected from communication, and it is by this sort of step-by-step logic that you end up with having to have everybody's consent when communicating. Yeah, so the reason is much, or the root is much deeper.
Okay, then a short counter-argument from Kai, 1 minute.
Well, I think I can provide the missing link. The missing link is that with communication becoming electronic, and especially with communication becoming fully digitalized electronic, like we have it especially with the OTTs, communication is much easier to survey and much easier to analyze. So what used to be difficult, like surveying communication and making it, and basic analyzing what people are doing, is now extremely easy because communication is digital and can be processed very easily. And since the Snowden revelations, we have seen that this is not only in theory possible, but actually happening. And that makes exactly the link between electronic communication and electronic surveillance. And I think that is one of the bases of the regulation. And it's logic, it's even smart.
Thank you. Maybe then I hand over to Caroline a bit. And
if I can chip in again about the law and ethics, rather ethics and artificial intelligence, that we frankly perhaps don't know very well where we're going. Again, sorry, I'm not an expert in artificial intelligence. What I know is that artificial intelligence debates have started thinking in 1952 with this famous mathematician McCarthy in the US, that they have for years and years debated about the definition of artificial intelligence, and that we're not, I think, not through the definition of artificial intelligence. So this is already a call to researchers. Now, we were speaking about ethics, and some would say, yeah, but law is what you can and what you cannot do. Ethics is what you should and you should not do. So the artificial intelligence will never be ethical. That's for the human. But no, we just don't know. Who says that in 2050 or maybe before, the ethics of the artificial intelligence will be higher than the human ethics. I think about a book that came out already in the years 80s about this spider who was a robot, and he had very strict instructions about by the human being. He had to do a lot of tasks, but there was just one thing he was not allowed to do, and that was to care about children that were less than 8 years old. Now, it happened that a child of less year old was in his environment and was in danger. So he saved that child. And he has the worst, it's a novel, he had the worst problems with the human beings because he transgressed the rules and this and that. Well, this is just open for food and thoughts that maybe there will be something like an higher ethical standards by the machine learning and by artificial intelligence.
And maybe could just, Caroline, who should do this kind of ethics watch? Police, Interpol?
Yes, Interpol, fully. No, this is a common responsibility of all sectors.
Okay, we have still some answers. Maybe there's one question around that you should also answer. And maybe do the last round before we ask some comments from the audience. Maybe Max Schrems can start a bit. You answered it already a bit. Can we achieve it on a global level? Or what we can achieve on a global level, what we should do on the European level? So when it comes to privacy, shall we stick to European rules, try to implement it here, and say there's another world outside where we maybe improve it in the future, but not yet. So we shall improve a very good standard here and also try to get what Bosch was saying, the technology is Asian, the software is American, so it takes a long way to work to make it work in Europe with IT security and privacy. Please.
Okay, I'm not going to answer the other things then, I guess. But yeah, I mean, a very short answer on that. We basically right now on a global scale have the Convention 108 model more or less that spreads out, and we do see that the European Commission is right now trying to get an agreement with Japan on being seen as an adequate country. We have South American countries and so on that join into that team, and I guess basically there are these two models, and I think the European model spread way further than Europe if you really look at it, and GDPR may help that a lot, and I think there would need to be much more kind of aggressive or proactive spreading probably of that model by the European Commission. And even if you look at the US or at North America, Mexico implemented a law right now as far as I know. Canada already has a law that follows 108. So it's really not a European versus American thing. I think there is very much a rather global coming out of Europe approach that oftentimes the details of actually come from US law if you look into the 60s, because a lot of these principles that we implemented, the Americans had first. But I think it's more of really, in my perception, oftentimes, if you look at it at a global stage, it seems like the Americans are becoming more of the outlier than the Europeans, because the one model does spread, the other one I don't feel spreads that far. But that would be the very short answer on that. Should I answer the other questions that were raised before?
Sure. Yeah, please.
Yeah, just real short. I think one interesting thing about the legitimate interest debate is the problem is that as the pro argument, we always have spams and the wonderful reasons why legitimate interests are important and crimes and whatever. But also the digital marketing industry says that everything they're doing is a legitimate interest, and that's a problem of the concept of legitimate interest. If there would be a narrow legitimate interest or something like that, we could possibly use that much more. But right now the industry is trying to squeeze out legitimate interest to be anything that possibly makes money, and that is probably not working then. The other thing that I thought was really interesting as well is what you said on transparency, and I actually join you for another reason, because I think transparency as we use it right now is oftentimes used as responsibility shifting. As soon as we have some kind of privacy policy, the user is suddenly responsible to read it all and understand it all, and not the company is responsible anymore to do it right. And that is exactly the American notice and choice principle. Like, we just put a notice on everything. On every toaster there's a notice that you might die from this toaster, and therefore we're not liable for anything. And I don't think this approach makes a lot of sense. It does make a lot of sense to have transparency for other reasons, but not for that reason, for all the reasons you debated before. The last point that I just had to make is, you talked about 100% compliance with privacy laws. I was biking here. I don't think I was 100% compliant with traffic rules, and I think our traffic would break down if we all follow the traffic rules 100%. And any other field of law, building codes, I don't know, would probably, the Germans are oftentimes much worse in driving, but anyways, being from the Salzburg border, we know. But that is the thing, we actually, it's not about the 100% compliance, it's the fact that right now the industry is oftentimes not even 1% compliant. And I think GDPR probably gets us to 50, 60, 80%, and that is what we usually need from laws. And I don't think it's a 0 or 100% debate. It's a moving towards the right direction, as any law. There is a murder, you go to jail for murder, but there's still murderers around. Yeah, full stop there.
Okay. Maybe Nico, second question, and then move on to Zoltán. Thank you.
The second question.
Second question also first, and then...
Okay, I promise to be brief, and I just want to make one observation there. Of course, there has to be global discussion about privacy rules. I mean, for obvious reasons, because we are talking about technology that that crosses any border, and we are talking about what we always say is a globalized world. Of course, we need a global discussion. What I observe is just the relationship between the United States and Europe that you touched on as well, Max. What my observation is, when I talk to privacy experts in the United States, they are much more interested in the European discussion than we Europeans are interested in the US discussions. Some of the greatest privacy academics, well, one of them is from, just looked at us, is from Zell am See, Meyer Schönberger. He is much more noted in the United States than he is in Europe, because he publishes in English. And there are other very, very distinguished academics in the United States who are sort of very convinced and very, very esteemed privacy lawyers. And I always have the feeling the interest in Europe is not really very great in what the discussion of the issues is in the United States. On the other side, we expect the United States to follow our rules. There are sort of, I hear things like, well, this is the gold standard now with the GDPR and everybody should follow the rules. This is an attitude that we have that is Eurocentristic and sometimes even arrogant, which I think is not good for the globalization of the discussion on privacy.
Okay. Thank you.
Thank you very much. I have to agree with a lot of things that I've just heard on my right-hand side here from both gentlemen. But I would say that very definitely in the 7 years I've spent in Symantec, I have seen a massive shift, even in the United States, when it comes to privacy. 6 or 7 years ago, when you went to the Hill and you talked about European privacy rules to Congress people there, they would laugh and say, yeah, we have the 5 principles for PII and that's good enough. Last year, the US administration signs up to a privacy shield which contains language copy-pasted from European standards, GDPR language. This has moved a lot. And I fully agree with Mr. Schrems that the European model is much more effective in exporting itself through adequacy, but not only. We as a company will try to go for the highest gold standard available in terms of how we design our technologies globally, because all our customers, not only in Europe but elsewhere as well, expect of us that, one, we are able to show compliance to the GDPR. We get interest from Australia, Japan, Canada, South America, plenty of places, the Gulf countries. Everybody wants whatever product or solution we bring to be GDPR ready. And number two, they want the assurance that if they work with us, that will not jeopardize their ability to comply with the GDPR. So de facto, the European standard is becoming the gold standard, the global gold standard. And we as industry, as far as my company is concerned, will certainly go in that direction as well. And I fully agree with you that global rules are a must. And I would even say that it's particularly in the relation of law enforcement and the private sector, it's not just a must. Accountability for how we collect data, how we process data, what we do with that data, what share of data we actually pass on to you, and how we exchange information. Accountability of all of that is the essential catalyst of trust, without which none of the exchanges would happen. And you said as much. The more your privacy policy becomes elaborate, the more information exchange happens. The only problem that I would leave on the table now is that no effort by industry alone or by unilateral legislation in one region will solve the problem that Max referred to, the conflict of law question. This is an intergovernmental issue that can only be solved at the intergovernmental issue, and the approximation of standards across regions is still very much work in progress, about which I would encourage everyone to cast their wary eyes to Brussels, where apparently the European Commission is to announce today 3 possible options for European legislation on how law enforcement could access data. It's going to be a fascinating discussion in the next couple of months, and I'll be very curious to see where the European provisions, whether at the EU level or in the national implementations, will land compared to something like 702 in the US, for example.
Okay, thank you. Caroline?
Yes, so I broadly agree with the previous speakers. If I just may add this, indeed, trust is much more easy to obtain within regions than globally, but it doesn't mean that we. But I think the issues we are talking about are global, so you cannot solve global issues by regional solutions, as was said earlier. We always will need this bridge towards the other countries. And we have to avoid EU isolation or other issues. Interoperability is very important. We heard conflict of law, and I would indeed stress that example in the law enforcement, that there are, for instance, binding UN Security Council regulations where member states are compelled to cooperate together in law enforcement, especially in terrorism, which you have to take into consideration. So we indeed, the conflict of laws and the interoperability between different laws is extremely important.
Thank you, Caroline. As you may know, I'm also an international lawyer, and when you hear about cooperation, I like it. When you hear about extraterritorial jurisdiction, like between GDPR already, it's a bit like that. Good for data protection, for data privacy, but still maybe in the long run we have more acceptance from most countries. So we would like to have some last minutes, panel, or yeah, maybe no, Max, Schrems? Maybe everybody 1 minute saying for the Caesar regulatory approach.
Just the only thing I actually still have right here is on what you said on the exchange US EU. And I think that's kind of interesting because the industry really looks into GDPR and so on. And there's a lot of interesting academic debate in the US. But the academic debate in the US is pretty much irrelevant in the US practice. Like, no one cares what academics write in the US in the legal practice. And in the legal debate, actually the US, in my view, is even more US-centric ever. Like, we had that whole debate about FISA and 702 and the Fourth Amendment. If you're not a US citizen, you're typically out of the game. In all of the debates, how far surveillance goes, it's all about is it a US person or non-US person. If you're in the category non-US person, debate ends. And I think that is a bit unfair to kind of put it that way. However, and on the practical kind of economic impact of privacy regulation, there is simply very little regulation after all in the US. So I would wonder what I would be interested in. I am interested, but there's not much. But that's the only point I actually had right here.
It's more interesting than you just said, and there are I could mention various areas where we can learn from the United States. Yeah, California has data protection laws that are different from the GDPR, but that are very, very interesting. But who of us really cares about data protection? I mean, this is not Nevada; it's Silicon Valley state. Who of us is knowledgeable? We expect the Americans somehow now to be very knowledgeable about the GDPR, and of course they are. And there's a lot of prejudice. For example, that it is only the Americans where it makes a difference whether you're American or non-American when it comes to surveillance. Yeah? Until very recently, data protection in our German laws on Secret Service there was no data protections for Austrians, because the laws only applied for Germans, etc. And one last comment: I was watching CNN, and there are, in connection with this Russia and Trump affair, there are all these committee hearings at the moment. And the heads, yesterday again, the heads of various the NSA, the FBI today, as many of us know, and CIA, they all were witnesses in public session. Something unthinkable in Germany. Until very recently, it was a crime for a member of the committee, or of the oversight committee for our Secret Service, to tell the other members of parliament where the sessions of the oversight committee took place.
Okay, thank you. Look to the facts, important statements. Thank you.
Thank you. A very quick one, but I'll take my conclusion more on the smart regulation bit. It was suggested earlier in the discussion that the GDPR addressed some of the easy topics around collection, but not the hard topics around processing. And I just wanted to disagree forcefully with this, because I think the GDPR is very smart in putting out there a number of quite strict rules, but not too detailed or too cumbersome rules. But there are plenty of rules that relate not to the collection but to the processing of data, starting with fairness and transparency, as was mentioned from the floor, but also on the security of processing itself. Article 32 is not the security of data, it's the security of processing. And I would argue that under Article 35 on data privacy impact assessments, the whole point of that is to make sure that accountability, privacy by design and privacy by default are built into not the collection of the data, but into the processing of data. And then you have all the other rules on specific processings, sensitive data under Article 9, profiling under Article 22, the whole Chapter 9 on specific context, which unfortunately differs to national legislation, which means that national laws will persist. Nevertheless, I do think that the GDPR has much more detail and much more helpful indication on processing, not just on collection, than we give it credit for. And I would say that the test of the pudding is when we eat it. So this is not a pun for the lunch that's coming, but I want to be optimistic and give the GDPR a chance to prove its worth, and we'll start to know as of, well, a year from now.
Thank you.
Two quick observations. One, I want to chip in on what you said as a public international lawyer and your reservation about extraterritorial effects of legislation. I fully agree with that. I think good legislation is when the one who have to implement the legislation feel the ownership of that legislation. So you, with extraterritorialism, it's very much more difficult to reach that ownership. That's the approach we took at Interpol. The last rules on data processing were really the ownership of the police. In fact, they came together. We just explained them everything. There were a lot of working groups, and they accepted the rules, although it was a heavy burden on them. There was a full chapter, chapter 4, on controlling mechanisms that are extremely heavy to implement, but they had ownership of that package of rules. And then a last comment is, I think, well, the minute that, at least for the law enforcement sector, the minute that you have transparency and oversight, the minutes you have solved a lot of problems.
Thank you. Thank you very much for this very interesting panel, to the panelists, to the questions. Then, very last remark before lunch. Yeah, we need also consent for slides, videos, audios, put in maybe for internal use, or as was discussed on YouTube. So please consider that. just to do an unfair consent provision. Everybody who goes to lunch agrees, immediately do that, and that's then documented. No, we don't do that, but we send out an email, and everybody who is uncomfortable with that, we take that into account. Okay, then, thank you very much.